It's been a big week in the IR space.
Absolutely.
Never a dull moment. There's been a lot of kind of preemptive discussion about the use of non-compete clauses in contracts. So it's not a huge surprise that that's coming onto the agenda. What's your feeling in terms of employers being ready for making changes to how they perhaps retain staff or deal with difficult departures?
Well, I think this will add an extra level of complexity. The first thing is they're going to have to understand what it means for them and look at how they can apply it for their workplace and their different categories of employees and what that means and how effective the ending of employment really needs to be for protecting the business while still meeting the prohibition that it looks like we're going to see.
Yeah.
It's a couple of years away, so there'll be a lot that we'll see in the interim, but certainly employers need to start thinking about what that means for them.
Yeah, and managing expectations around departing employees. And at the moment, I think what we find, the existence of a non-compete clause in a contract is often restated at the end of the employment. So a termination letter will often include a paragraph that says something like, and by the way, we remind you you've got these obligations that continue after your employment.
Yes.
And they tend to reinforce the existence of these and that the employer intends to enforce or rely on those. But I think that they've always been problematic for employers in the sense that they can never engage in those types of discussions or those communications with any real certainty about their ability to actually act on what they've said they're going to do.
Yes.
And so in some respects, reforms in this space will possibly require a rethinking of strategy. If I remember correctly, the government's narrative on this issue was employees shouldn't be held back from taking the next step in their career, achieving higher salaries through, taking up better offers. I don't think non-compete clauses have ever been designed to have that effect, but to the extent that that's an issue, employers perhaps need to be thinking more proactively about how they offer their existing employees development opportunities and career progression, and that they're meeting salary expectations so they can retain staff. One way of thinking about it.
Definitely being open and honest in that communication as well, the expectations for the employer. There are some workers who will move from jobs that go to very similar jobs. As an example, hospitality, nursing, so it's looking at the industry, it's looking at the role, it's looking about the type of job and what's likely to happen in terms of, is a restraint going to be necessary to achieve what you want to achieve, which is maintaining what you need to maintain moving forward.
Yeah, whether that be employment with the employee or whether it be the client relationship.
Yes.
I also get the feeling the high income threshold is coming into a moment of its own. It's being treated as, well, this is actually the threshold for when we think people are not vulnerable or not likely to be exploited.
Yes, and there's also that's the point where with the new definition of employee and employer, a contractor can opt out of being assessed as anything other than a contractor.
Correct, yeah, which seems fairly arbitrary to me.
Yes.
I think the announcement that we heard this week was that will be imposed as a way to delineate when restraints are capable of being used.
Yes. Because there's that view that when you're earning over that high income threshold, there's a point where a discussion is perhaps more likely, a reasonable discussion, an agreement outside of a restraint provision.
There's a lot of assumptions in there about the person's capacity to have a negotiation with their employer about the terms of their employment, which follows logically, but doesn't necessarily resolve any of the underlying issues. But that's the point, I suppose.